goes about documenting satisfaction of that goal will be important.
Right. Although it is interesting because numbers do come in, right?
Right.
So Texas made, I think, a very important argument about tokenism, that when you do an analysis and you find that you have one African-American or Latino kid in a classroom, that's not an environment that creates the kind of compelling interest benefits of diversity that we're talking about.
Right. And I think that's important for universities not to lose sight of in the way that you all didn't at the time that you were litigating Grutter, right?
Yeah.
And to explain, this is what we want to deliver to our kids, this is what we're trying to foster on our university, and this is what the end result is when we want the kids to leave our campus.
Exactly.
It's not just who's here, but how does the conversation unfold on the campus.
Exactly.
I wonder if I could also just hijack this conversation.
Oh, go ahead.
Just to say that, I think what Dr. Krislov raised about ensuring inclusive environments after you admit students is really critical. I think that typically the diversity discussion gets framed as a matter of consideration of race in admissions, and that is an important first step to both recognize that getting students of diverse backgrounds into your institution is sort of the initial building block for the diverse educational environment you want to build. But it can't stop there. And without the kinds of supportive, inclusive programs that it sounds like both Syracuse and Oberlin are developing, often whatever work you're doing at the admissions level will not be successful over the long term. So I think that one thing to bear in mind is that similar standards will apply to evaluating race-conscious programs that you undertake for your current student body. In addition, you need to be alert to ensuring that there aren't overt forms of discrimination on your campus that send counterproductive messages that your diverse student body are not welcome. So, for example, just a couple of years ago, we entered into an agreement with the University of California at San Diego to address pretty egregious racial harassment on the campus, where there were nooses and KKK symbols that were posted, and parties off campus where people were encouraged to come dressed as stereotypical African American characters. Those kinds of activities are against the law if they are sufficiently severe or pervasive to alter the environment, which at UC San Diego we thought they were. But in addition, they undermine the goals of creating a diverse and inclusive environment. So just at a very basic level of ensuring that you are not discouraging all of those students you've worked so hard to get into your campus, you need to be alert to what's going on in the campus environment as well.
I'll just say something that's probably pretty obvious, but I think it's an important part of the discussion. I think in making the judgment about how things are working, it's important to look toward the faculty who really are the experts on this. And so at Michigan, the Michigan law policy came out of a faculty committee that defined the objectives of the institution and defined the ways in which those might be achieved. At our institutions, we all have committees that are charged with this, and they, in tandem with probably general counsels, but also people who are really fundamentally concerned with education, do need to think about how things are working. And, these are not easy judgments to make. In the Michigan cases, we had testimony that clearly illustrated instances where there was not anything approaching critical mass, and it had negative impact on the classroom. And there was some very important testimony from university officials, including Nancy, and the dean of the law school, about the way in which achieving some sort of diversity in the classroom and in the community contributed, and the absence of such was a negative and undercut the educational admission. So I do think that the faculty who are in the classroom, who are in charge of the teaching and learning, actually need to be part of this discussion. And it may differ from campus to campus in terms of the types of programs and the types of goals of the campuses.
Thank you. Thank you very much for all of that dialogue. And now I'm going to ask the audience to help me and to step forward with questions. We've reserved time for audience questions, and you are most welcome. to pose them to us. I think we have a candidate stepping forward.
I'm Richard Collenberg with the Century Foundation. This is a terrific discussion. I learned a lot and want to thank you all. So you all emphasize the continuity between Grutter and Fisher, and surely there is a lot of continuity. At the same time, there were 5 justices who were on both courts, 4 of whom switched sides. So you had Justices Kennedy, Scalia, and Thomas, who were in the dissent in Grutter, who were in the majority in Fisher. And then Justice Ginsburg switched the other way, going from the majority in Grutter to the dissent in Fisher. So presumably there is some difference between the 2 cases. And I wonder if you all would elucidate what you think are the differences between what the court said in Fisher and what it said in Grutter.
Time. I think, there was years apart, but otherwise, I really don't think that there was a difference in content. The court's language itself is a language that we have to live with and that is binding, and I think that there's not particular value in counting votes on who was where. The end result is that there was a 7-1 decision that said that the prior line of cases is still the law, and that is the end result of Fisher. So I actually don't see that there is a distinction in the decisions.
Thank you.
Hi, I'm
Yes.
Josh Dermott. I'm with the National Association of College and University Attorneys. And one thing that we hear a lot from our members, a question that comes up, regards race-based scholarships. And I think they hear this a lot from donors who say, we want to give you $1 million, but it can only be used for students of color, or even more specific than that, Filipino students, something like that. And our members, quite frankly, aren't sure whether there's been official guidance on that, how closely they should look to things like Fisher for that guidance. So if you have anything you could elucidate on that, that'd be great.
We do have guidance, so thank you. Look what it's.
Did you plant that?
I wish I had. There's 1994 guidance that it still holds, and it's available on our website, and also I think it's linked in the link to this invitation. And if you have any trouble finding it, you can certainly access it by calling anyone in our office. But the short answer also is, first you should say thank you to those people who would like to give you money for scholarships. and second, your goal is to make sure that the race link in the scholarship is part of a compelling interest that is narrowly tailored, and you follow the same steps that you would follow the rest of the discussion that we've been having today. And we have a much longer answer to that in the 94 guidance.
Is it permissible for the institution itself to be distributing those scholarships, or do you think that it's preferable for the outside organization perhaps to distribute those? Do you see any difference in that?
To the extent that another entity wants to do the distribution, that's always nice. But if the university has identified a compelling interest in achieving diversity that for which there are no workable alternatives that could be administered at tolerable expense, I say as the key words, then a race-based scholarship can be administered by the university as well.
Thank you. Other questions?
My name is Brad Quinn. I'm from the College Board, and I'm the manager of what we call the Access and Diversity Collaborative, which is a collaborative literally of 40-some-odd institutions and organizations who have dedicated themselves to being leaders with respect to the practices that on their campus and the like. But I'm glad the first question was raised, because I want to go back to it just in a slightly different perspective. We work with admissions officers on a daily basis, and certainly some of the concerns we've had with respect to the case when it was finally adjudicated was we didn't want institutions overreacting to what occurred and underreacting to what occurred. And certainly in that case, without reading tea leaves, or by reading tea leaves but without counting votes, there is a tone associated with that decision that suggests go ahead and bring the next case. Irrespective of what will happen in the Fifth Circuit with respect to the review and the hearing, we're concerned as an organization, and some of our members are, that this is an issue still pregnant with the possibility of some fairly serious reversals. And of course, we try to develop materials and the like to help people cope with the current ruling and the understanding of the current law as it exists. but also we anticipate that there could be some difficulty down the road. Would any of you like to comment about that? And I'd also like to invite Syracuse and Oberlin to join the collaborative.
What's the cost?
After we give up the SAT.
So I see some whispering. I'm just going to jump in. I don't read the tea leaves the way that you do. I think that the decision was typical of Supreme Court decisions in that it clarified what the standards are and applied them in that instance. I think we all worry about potential reduction going forward, but stare decisis is what it is. For lawyers, and the court sent a very clear signal in Fisher that 40 years of precedent still stands, and that is the precedent that universities are expected to apply, and that the lower courts should apply following Fisher. So I read that as good news. I do not read that as an invitation to further litigation, but we don't control what people do.
And I just also want to say how important that comment is for higher education leaders, and you well know this. The last thing in the world we want right now is a whole set of higher education leaders running away from this. And if there's anything really important that Fisher added, as I said earlier, in my view, to Grutter, is this notion that we think thoughtfully about what it is we're doing, the kinds of things Jocelyn was talking about. In order to create an environment where higher ed leaders feel comfortable doing that, you can't scare people into thinking the next case is coming. And so I think it's terribly important, and in that regard, the sense in which so many justices sided with the decision is something for us to take heart in, not to say, oh, this was a next case in the making.
Good morning, everyone. My name is Zainab Okolo. I'm an undergraduate coordinator at the University of Maryland and a not so recent, but recent graduate of Syracuse University. As an undergraduate coordinator, I actually started off at University of Maryland as an admissions counselor. And so right there I saw how Maryland takes the time, I'll brag about my school a little bit, to really incorporate minorities, especially that are from underserved populations or first generation in particular that might not have the SAT scores to get in. We have transitional programs, and also we do have collaborative efforts with local community colleges like Howard Community, PG Community, so if they do 2 years there, they can come to Maryland. And one thing that you said, Dr. Krislov, is we don't want to undermine our students, so when we let them in, we want to be able to retain them and get them out within 4 years. Are there any policies that we're working on right now at the government level to create a standard of how professors interact with students that may be first generation or minority students? And by first generation, I mean they're the first in their families within recent centuries to ever go to or almost attend, almost graduate or be close to graduating college.
Government.
Yeah,
She's a government. I mean, I can talk about what we're doing, but I'm not the government anymore.
But I don't think that's...
So the concept that you're talking about of supporting students is one that that we actively support also, and we would love to provide assistance in ways to make sure that those are lawful and well used. The hesitation I think that Jocelyn and I are both feeling is that we don't like to tell universities how to do their jobs, and that it is that the First Amendment does say that the universities get to make that decision themselves. And so as long as they are performing their mission in lawful ways, we love it.
I might just add, and something that you said made me realize that perhaps we haven't covered this point in the panel. Where universities engage in programs that do not take account of an individual student's race, the standards are not as strict. So if, for example, you have partnerships with Prince George's Community College or Howard Community College, where you are doing work that supports those students in their transition to four-year institutions, there are not the same levels of legal constraints. Even if you are doing it as part of your effort to promote racial diversity on your campus, because you are offering benefits to students who attend that college, whatever their race. It's a different kind of analysis, and I want to really encourage universities to look at those kinds of pipeline programs, and it sounds like Syracuse has engaged in substantial numbers of community collaborations, because those are not directly addressed in Fisher. And if you look at our guidance documents from 2011, particularly the one that applies to K-12 schools, you'll see lots of examples of the kinds of programs that we think can be lawfully implemented that are designed to improve diversity but don't look at individual students' race.
I would just say that one of the takeaways, I think, from this discussion is how difficult our task is and how much it requires sustained work and how much we will not always succeed, but we have to keep going. And it takes not only will, but resources as well. And I think, we have programs like Student Academic Support Services that are available to first-gen and other disadvantaged students. We have research opportunities that are targeted toward those students. We have work-study programs that support students so that they can do things that advance their career interests while earning the money they need to get through college. And I'm sure Nancy and other excellent colleges and universities have these programs. They cost money, and it's not easy. And Richard, I thought that, if I can just say that one of the things that I would hope that those people who are focusing on admissions realize is that it's very difficult work, but it's critical work. And that's why we need partnerships, and that's why we need support. And I do think that, we used to say at Michigan that the essential issue here was there were two reasons why we needed to think about these issues. One was because the pool was not what it should be, and the other is that young people were growing up in communities that were not interacting with each other. So it's so important that they had that experience when they came to higher education to interact with people from different backgrounds. We can continue to work on that, exposing people to different people from other backgrounds, but I think it's also the pool. And once we develop the pool, we need to maintain the pool and so forth. And that's why I would hope that the public discussion of this would focus on that aspect, rather than on one tool, which is frankly a small tool that applies to a relatively small number of people. It's a much bigger question and a much bigger problem. And I would hope that we could move the public discussion in that direction. And I think Nancy's piece in the Huffington Post certainly tries to move us in that direction as well.
Yeah, I think that's so important. And I just want to underline the notion that this is hard work, right? I mean, you know this, right? And it is not the case that, when we were doing the Michigan cases, we used to get those, and I'm sure they're media here, so I'll be nice, but we used to get those journalists in our face saying, well, you tout this diversity and the compelling educational benefits of diversity, and all your African-American kids are sitting at one table and all your white kids are sitting at the other table. And I used to say, this is not something people are genetically predisposed to do. You don't come to an environment when you come from de facto segregated life environments. You don't suddenly come to an environment and all of a sudden you're completely interacting across lines of difference, of any kind of dimension of difference. This takes deliberate work. And part of the work of understanding what it means to cross boundaries of difference is understanding what it means to affirm within group solidarity and coherence. And we have to do both. And so when I think of first-generation programs, for example, we spend a lot of time at Syracuse trying to create a sense of affirmation, of belongingness for first-generation groups of students before and at the same time as saying, and now this campus, you own it. Go interact, But I think it's so easy to forget the work that you do and others do. Yeah.
Good afternoon. My name is Camille DeJourna. I'm the Associate Consultant at the Section on Legal Education at the American Bar Association. So I'm here to ask what you think Fisher has in terms of implications for the accrediting process, for example. So obviously, we have diversity standards and regulate over 200 U.S. law schools. At the moment, we're not asking the question about assessment of those programs, right? Mm-hmm. I think in that pretty old school way, we're looking at the numbers to reflect what the assessment is of the program, right? Is there an actual impact, right? So what latitude do you think accrediting bodies have with respect to enforcing these kinds of programs for our schools?
Certainly a leadership role. I mean, one of the premises of Fisher is that universities have the latitude to decide for themselves whether they will seek to achieve diversity in the first instance. And so the accreditation inclusion of diversity as a goal is a leadership role, and one that we in this administration hope that you don't walk away from. But beyond that, I like to think that it's our role to enforce the non-discrimination principles, but that might be too narrow a view.
I guess what I might add to that is, I think that what we've heard from our university colleagues, and certainly what the law requires, is that this process of seeking diversity needs to be a holistic one and needs to embrace a host of programs and approaches and supports, starting with transition programs into higher education, to admissions, to programs on campus. And I think that if there is administratively a way to evaluate the holistic nature of the university's efforts in trying to achieve these goals, that's the kind of thoughtfulness that Dr. Cantor and Dr. Krislov have been talking about, and that I think we'd like to see universities engaging in.
I think we can take maybe one very quick question here, but before we wrap up.
My name is Scott Graytak. I'm an attorney with Campina Code. A lot of the racial demographics in certain states in the South, be it Mississippi, Alabama, Arkansas, North and South Carolina, have racial demographics that range from 15 to 45% black populations, and yet the overwhelming majority of the flagship universities in those states, which use diversity-oriented rationales for affirmative action, have rates that correspond to anywhere from 4 to 12% black student populations. I guess first and foremost, is this a disparity that is relevant to the affirmative action conversation? And if it is, what's going wrong? What can we do?
We have to get a quick answer to that if we have one, because
I don't think there is a quick answer to that. I mean, the flip answer is that those kids are going to Amherst College instead, where I went. But but the less flip answer, is that there's not going to be numerical symmetry between student populations in the K-12 system in a state and the student populations in the elite institutions in the state. There isn't going to be that level of symmetry, and so we know that there's work to be done so that we can achieve greater and more diversity, and we have to look at more of the numbers.
And what I'd add to that very quickly is just that one of the components of this that we haven't addressed but that's very important is that universities look at their practices to see if there are things going on that are screening out candidates of any description, whether they are candidates of color, candidates with disabilities, candidates who are too poor to attend, because independent of race-conscious decision-making in admissions, it is incumbent on universities to eliminate practices that artificially are screening people out. And so that's a kind of first step of the process. Are you doing things that are inadvertently sending a message, for example, that certain kinds of students are not welcome on your campus? And that's a matter of non-discrimination. You've got to fix those.
Yeah, and that's a good point to close, and to invite our closing remarks from Anarima Bargava and Seth Galanter.
So I'm going to be really brief. I don't know if this is on, but I'll try to talk loudly, and then turn it over to Seth. Just first, I wanted to address your question about challenges, legal challenges, and as everyone has talked about, this should be a moment of care and work. It should not be a moment of fear. And the reason that's important is because we have the same cycle after Grutter, and it's important to note that Fisher is the one and only federal challenge we've had to a university admissions program since Grutter, right? And so we're going to continue to have the fear rhetoric play out, but I think for university councils in the room, what we are trying to really signal is it's a moment of care and work. Secondly, some of the language of Grutter, and certainly that's reflected in Fisher, that is incredibly important is that of the open pathways to leadership. And the reason that we want to emphasize that language is because it matters, as Undersecretary Cantor would certainly tell you, that we're telling 7th graders and 8th graders that college is an opportunity for them, it's an expectation for them, it's something that they should look forward to going to. And if we can have a pipeline that really signals that and has an open pathway, that is one of the major ways in which we can actually have a very different kind of student population who is coming to our community colleges and certainly to our four-year colleges. And to use the farm team analogy just once again, I think it's not only important who's on the farm team, but it's important that they go to the minor leagues, it's important that they go to the major leagues, but it's also important that those are the people who are going out and being the high school coaches and the little league coaches, and that they're bringing that back into the communities that they came from. So, all of this is part of a pipeline, but also of the legitimacy of the democracy that we're a part of and the stability of the society that we're a part of going forward. And if I can just close by saying something, actually two things. One, we should also think creatively and carefully about what we do in terms of diversity, and certainly not only think about how we think about race as a factor, but all the other factors. And so when you talk about first-generation students, what are the ways in which we're weighting different things in our admissions process, and that being something that we're very careful about as another way to bringing students in. And so it's not just how we weight race, it's how we weight everything else in the process that we should be thinking about. And lastly, a moment of personal, I've been saying this for a while, and so I'm going to say today, to me, this is a question of going back to the beginning of why segregation matters. And I would say only this, which is, the city of Sanford, Florida was under desegregation order until just a couple of years ago. And I would just like to think about how it might have been a different story had we actually had the kind of cross-racial understanding, the kind of ways in which we promote respect instead of fear in places like Sanford and in places around the country where we're now trying to deal with aftermath and instead of having to actually address the ways in which we can learn and play and grow together at the beginning.
Wow, I'm Seth Galanter. I don't know how to beat that. I mean, I already was intimidated because both my boss and Anarima's boss was on the panel, and we had such an amazing panel, and then Anarima had such a whole constellation of amazing ideas. I guess I would just say, on behalf of the Department of Education, we agree with everything. It's an organic process. It's a baseball team. It's a pipeline. It is. It is. Whatever metaphor you use, I think everyone here acknowledges it's hard work to have a community that you can recruit from, to recruit them properly, to admit them, to give them the supports, to retain them, to graduate them, so that they can go on to be civic leaders, to promote democracy, to grow the middle class, whatever the ultimate goals are that education is for. And as my boss said, and repeated, and I think is important, what the role that we're playing here and the role the race plays has to be looked at in the context of all of that. What is workable? What is sustainable for the institution? It's not going to be the same answer for each institution, but as I think Chancellor Cantor mentioned, that Susan Sturm at University of Pennsylvania, who was one of my law professors, said, it's about an architecture of inclusion.